or good morning, depending upon where you're calling in from. I'm John Shalafo with Mira, and I'm joined here by my colleague, Cheryl Dry. And we're happy to bring you today one of our continuing webinars, Patents versus Trade Secrets, Knowing and Protecting Your IP. And our guest speakers today are Mitch Zajac and Ziad Hermes, both with Butzel Long. But before we turn the mic over to Mitch and Ziad, we'd just like to cover a couple of quick housekeeping items related to the webinar. And the first is related to questions. We'd love to get your questions. And for those of you who've participated in our webinars before, right on the right-hand side or on your screen, you can submit questions, or you can send your questions to info@mira.org. And with that, we're going to continue. So we'll have a presentation, and we'll follow with the Q&A session. And for those of you that participate in our council meetings, you'll recognize Mitch, and he's covered this topic for us in the past. It's a good popular one. Again, patents versus trade secrets. And Mitch and Ziad are going to take us through some of the key points that you should know. With that, I'll turn it over to Mitch.
Thanks, John, and thanks, Cheryl. Good afternoon and good morning, everyone. It's a pleasure to be with Mira again. I just want to go through a quick introduction of myself, and then Ziad will do the same, and then we'll jump into the presentation. As John said, my name is Mitch Zajac. I'm an attorney, patent attorney in the Butzel Long Detroit office. I focus my practice primarily on automotive and intellectual property law, and I dabble in a few other areas, commercial litigation as well. I've been with Butzel for almost 3 years now. But prior to that, I was an engineer at Fiat Chrysler with a background in design engineering as well as project management and a short stint in the audit and vehicle safety group as well. Ziad?
Hello, everyone. My name is Ziad Hermes. I am a commercial litigation attorney here at Butzel Long in our Detroit office, and have been here at Butzel Long since 2007. I do business and commercial litigation, generally speaking, but I also have specialty in trade secret and non-compete litigation, as well as some other areas like franchisor, franchisee disputes, shareholder disputes, et cetera. And done a lot of trade secret litigation, particularly in the automotive industry as well. So yeah, glad to be here this afternoon.
All right, so let's just jump right in. As John mentioned, our topic, and hopefully as you can all see on your screen, our topic is patents versus trade secrets. And this is really a continuation of a series of presentations we've done about protecting your business. This one is an important presentation, I think, especially in the remanufacturing space, because there are a lot of questions that come up about not only do I violate somebody's patent or infringe on somebody's patent, or is that person infringing on mine, but then also understanding and using as a sword the doctrine of trade secrets. So what we will do is look to cover a few different areas. First, talking about data ownership and IP ownership. We'll dive into patents specifically, and Ziad will dive then into trade secrets. We'll talk a little bit about what might be right for you, whether it's patents and, depending on your situation, trade secrets. And then we'll end the presentation with some tips on protecting your intellectual property, as well as some time for question and answer. So jumping into ownership of information, data, and inventions, the question becomes, who owns the data? First, we look at who owns the company's work itself, and it can be based on a variety of different factors, most frequently based on the practices of various companies. We see in employment agreements that the company ultimately will be the one that owns the data. However, there are situations where employees have negotiated, whether it be through their employment agreements or through separate agreements, the right to continue to own the information, the data that they provide, or also in situations where they do the work outside of the company, there's implications that need to be considered with respect to data ownership in that situation. So all of that said, the short answer is it depends. First question we look at is, what did the parties agree on? As we mentioned, employment agreements, they oftentimes will have specific language that we'll need to look to in order to understand what the deal was between the employee and the employer. As I mentioned, the invention or the innovation perhaps could be assigned by that employment agreement or by a separate agreement to the company, or likewise licensed to the company in the side deal. There's a phrase in intellectual property law called work made for hire, and oftentimes these exist as a part of employment agreements, but oftentimes they can exist in separate agreements as well. So the answer to our question of who owns the data may come down to a side agreement based on a work made for hire. And then the last question we need to understand is, in the case of a patent, for instance, did the company do the work to file the patent, and is there some sort of implication based on that work that the company did in filing the patent that would implicate who owns the rights to that information? So the work made for hire, I know you can all read this, so I'll boil it down to a short phrase is, was the employee or the person doing the work hired specifically to do the work that they did? I know that sounds kind of funny to say it that way, but in essence, did I come to my job for the purpose of doing this work, and is the result of this work some sort of intellectual property? The phrase you see on the screen is, was I specifically ordered or commissioned to do the specific work? That will need to be, as you see on the screen, something that's stipulated in writing. And so as a tool for business owners, we often recommend that we take in an express language, and it may increase the length of your documents or your employment agreements, but to be express is a requirement of a work made for hire situation. And most typically these apply to, as we say, the registerable IP. So Ziad will talk a little bit about trade secrets and how those aren't necessarily able to be registered in any office, and the implications of secrecy that help those be a valuable piece of intellectual property. But there are many other types of IP, patents, trademarks, copyrights that require registration. And in order to protect the work in a work made for hire situation, we need to be express with our language. So I did mention a couple of scenarios that cause different considerations to be made. One of those scenarios is the employee inventing something on their own time while at home. Many of us continue to work from our couch, so the question becomes, well, was I doing the company's work at home, or was I doing something on my own? There's a variety of factors that, this one bullet point itself could be an entire webinar talking about, is it the normal task that you complete? Are you using information you learned from your role as an employee with a company? All considerations that would go into deciding the answer to bullet point number one. With respect to bullet point number two, it's a similar discussion. Am I working in the scope of my role where I'm expected to make improvements on my design? And many times, I know in the industry that we work in, with respect to remanufacturing, there's innovation that's happening all the time. And so if there's a new way, a new process used for remanufacturing a specific product, the question will become, is this something that I was employed to do? I was hired to do this? Or is it something that is my own kind of invention, as my own work that I do at home, not on the company's time? Am I looking to improve upon this design, this process for my own purposes? And then the other consideration we see quite frequently is what we've characterized as the Google 80-20 policy. And effectively what that says is the company may encourage employees to do their own work during company time. So the policy at Google allows for an employee to be working on their Google workstation, but doing their own side business, their own personal business, and not implicate ownership requirements of the company. So the bottom line after those several slides is, let's be express, let's put it in writing, and leave the gray areas out of it. We'll jump now into just comparing patents versus trade secrets with that background on data ownership in mind. And many of you may know this, but what is a patent? The patent is a grant by the USPTO for meeting certain criteria. Those criteria being that an invention is new, it's useful, it's not obvious to one of ordinary skill in the art is the operative phrase. And if that is the case, if we can check those boxes, and we can check the boxes of providing enough description to enable somebody else in the art to create the invention after we disclose it, if we can make sure we disclose the best mode, it's called, for the invention, then we will be able to achieve under U.S. patent law a patent for that invention. And I mentioned the enablement and the best mode kind of buzzwords, and the reason that I mention those is because the goal of the patent system is actually one, what I like to say, it's a goal of disclosure. The idea back in the 1700s when the first patents were starting to be written was to promote innovation. And the idea of the patent system has kind of ebbed and flowed, and there's been times where more patents have been issued and less patents have been issued in certain other decades. But all along, all along, the purpose of the system has been to encourage disclosure of those inventions to the public, to facilitate commerce and commercialization, and to continue to drive innovation. So continuing on with what a patent is, it's a grant of what we like to call a property right, and I'll talk a little bit about what that means here on the next slide. But generally speaking, when you receive a patent, you have about 20 years from what's called the earliest filing date to enforce your patent, and it can only be enforced as to products and imports into the United States, the U.S. territories, or possessions of the United States. The patent, in being a property right, is sometimes a little bit confused with the idea that if I have a patent, I have the right to sell or make my product. That's not necessarily the case. Actually, the patent code tells us that a patent only allows me to exclude others from making, using, or selling the invention or otherwise importing it into the United States. There is not a right to make or use or sell or exclude others. There is not a right to make or use or offer for sale or sell your product or to import your product. There oftentimes can be other rules, other laws, other agreements that prevent a patentee's own use of their patent other than for the purposes of excluding it, others from using it, There's three different kinds of patents, and we won't get into the details of all of these, but utility patents are offered for things that are functional. Design patents are for aesthetic designs, and plant patents are just as they sound. They're for the creation or invention of new plant species. So ultimately, there is a trade-off, and this starts to set us up for our discussion on trade secrets. But there is an exchange that is made for the right to exclude. That exchange is the idea of disclosure. A patentee has to disclose their new technology. They have to provide enough detail about it for another to use it, that other person having the requisite skill to know how to use such an invention. And in exchange for that disclosure, they have a approximately 20-year monopoly on that technology. However, once that monopoly expires, once that approximately 20 years passes by, anyone can use the information that was disclosed as a part of the patent or that would otherwise have infringed on the patent claims. They can use that information without restriction. Once we have a patent filed and it's properly issued by the USPTO, there's several remedies. This isn't really a focus of our presentation today, but it's one that business owners should certainly be mindful of, especially when comparing to trade secret law. In general, there's the right to seek an injunction or prevent others from using a patent for patent infringement purposes. There's the ability to seek money damages, and as businesses, there's actually a lost profits provision, which is not the same as if an individual owns a patent on a product. You as a company can say that but for their use of this project or this product by this company, I would have made all the money they made, or I would have made more money. And there's also provisions for what's called treble damages, where if the party that's infringing on your patent uses your patent and knows that you have a patent, there is an increased or multiplier applied to the total damages allowed. Attorney's fees, which we appreciate, are potentially included as a remedy for patent infringement, as well as based on the forum that a lawsuit is brought in, whether it's in district court, federal district court, or in the International Trade Commission. There's opportunity to seize or destroy or impound infringing or imported goods.
Okay, everyone, this is Ziad Hermes again. I'm going to be shifting the focus now to trade secrets and kind of telling you a little bit about what those are and identifying them. First, we're going to start off with kind of just a general definition of what a trade secret is. Okay, it's just information that the owner has taken reasonable measures to keep secret, and the information derives independent economic value from not being generally known to and not being readily ascertainable through proper means by another person. So, in other words, it's kept secret and it's valuable because it's kept secret. Now, unlike patents, obviously, which Mitch was discussing, that there's a public disclosure with respect to the patent. So as part of the application and publication process, you are disclosing what your patented technology, the design or utility is to the whole world, but you do have this 20-year right to exclude others from being able to use it. So with respect to trade secrets, it's the exact opposite. I mean, you are essentially maintaining the secrecy of that information. Others can still use that information and product so long as they come up with it on their own or discovered it legally. So if you maintain the secrecy of the trade secret, you do not have to publicly disclose it, although others can use it. So there is no right to exclusion, although obviously if it's maintained as a trade secret, no one can misappropriate it. That would be a violation, but there's certainly you're not excluding others from being able to use your trade secrets. So just as I just suggested that obviously if others illegally steal your information, you can bring a suit to recover damages, which includes lost profit, potential royalty fee, unjust enrichment. And you're strategically not gaining the right to exclude others by not disclosing the information. You can also seek injunctive relief. For example, if you have reason to believe that somebody has misappropriated your trade secrets or have not created it lawfully themselves, then you can certainly go into court and seek an injunction, obviously preventing or precluding them from continuing to use your trade secret. Remedies include damages for the actual loss, the unjust enrichment that the misappropriating party might have benefited from use of your trade secrets, and in exceptional circumstances, for example, if injunctive relief would be inequitable, a court may order a reasonable royalty to be paid, and there's certainly much case law out there in terms of how to calculate that royalty, whether it's the value of the trade secret or essentially the harm that was done to the holder of the trade secret. You can also recover treble damages, which Mitch referred to as essentially a multiplier. And if you have actual damages, for example, of $1 million, then you can multiply that times 3, and you can possibly be entitled to 3 times the amount of damages plus attorney's fees as well. So companies will often have to make a choice, essentially. Do you patent or do you keep it a secret? So obviously, you can, if you can have your information patented, you can do that. You'll have that 20-year right of exclusion, but it will come at the cost of having to disclose it to the world. Or you can keep it a secret, but run the risk that someone else discovers, develops, or comes up with it on their own. Like, for example, they can reverse engineer it. But those are kind of the decisions that companies often have to make. And some of the classic examples, for example, with respect to trade secrets, Coca-Cola and Kentucky Fried Chicken. I mean, these are two of the most referenced examples out there when talking about trade secrets. For example, Coca-Cola's soda recipe or the Kentucky Fried Chicken recipe. These are things that have existed for years, and yet there's still company trade secrets for those companies. And as long as they're maintained, as being secret, then and nobody learns of the secrets, at least not through illegal means, but as long as that they're kept secret, then those companies can continue to maintain them as trade secrets forever, essentially. Others obviously would opt for patenting the technology themselves. And by doing that, they do have the right to exclude others from being able to use them, or they can permit others to use it, maybe via licensing or other type of arrangements where they can extract kind of royalty fees or something like that for allowing others to be able to use it. All in all, it's a legal and business decision together, so you have to balance certain factors with issues of disclosure. And I'm going to turn it over to Mitch. He's going to kind of walk you through a chart in terms of kind of the decision-making process and coming up with either a trade secret or a patent.
All right, thanks, Ian. So what we're faced with now is how do we make this decision? We've given you a 30,000-foot view of the different levels or the different bodies of law that govern trade secrets, that govern patents, and the very basics about what types of information is needed in order to pursue that path. So I'd like to now just walk through a decision kind of hypothetical that would allow us to either land on patents or land on trade secrets. So imagine you're company X and you have this innovative idea for your project. At first, it makes sense, and we recommend this, that we practice secrecy in our innovative ideas. And Ziad will talk about some tools of doing that here a little bit further on in the presentation. But initially, everything starts out as a secret. And then in order to become a trade secret, there are certain decisions, rather, that need to be made and different protocol that needs to be followed to be able to, as Ziad has explained, maintain the secrecy of that innovative idea and solution to that idea. In a later stage, whether it be the next week or after a year of development work, we're faced with a question we have to answer, whether or not the product or the innovation is patentable or if it's not patentable. In the instance where it's something that's not patentable, in such a case as it's something that's not new, such that it qualifies under the U.S. Patent Code as a novel invention, there are opportunities to protect that product or that solution under trade secret law, under copyright law, or under trademark law. If, however, the product is patentable, that's where we reach the business decision stage. If the product is a patentable product or the solution is a patentable solution, we can have patent either exclusively, we can have trade secret exclusively, or we may be able to include both the patent and the trade secret together for part of the idea or part of the solution. As we've discussed in the past, patents are not able to be issued for ideas themselves. However, trade secrets have a little bit lower burden of proof or a burden of sustaining the intellectual property rights, such that all you have to do is be able to show that it's valuable and keep it secret, whereas patents need to satisfy certain criteria in order to be considered patentable and then ultimately to have a patent issued. So, for instance, specific design elements of a product may be patented. However, the process for making those design elements in a manufacturing setting may be protected as trade secret. So you can see how those two types of intellectual property might be able to work together on just a single product. In the event that we choose a patent, the steps to proceeding to receiving your patent on that product or on that innovation are, again, at a 30,000-foot view highlighted on the screen. We need to be sure, in fact, that the innovation or the invention is novel. So nobody else has written about it, nobody else has manufactured it, nobody else has done what you're doing before. Then we make the decision of provisional or non-provisional patent application, where a provisional application is, I like to call it, a stake in the sand, gives the patentee or the inventor or the assigned party, in the case of a company, the ability to kind of kick the can down the road with respect to filing and spending the money and the time and the resources to develop a full patent to the tune of about 12 months from the date of filing. And then the non-provisional patent is the steps we would take in order to pursue that right to 20-year exclusion for the intellectual property that was developed. Next stage will be prosecution of the patent. It's a process where attorneys like me would work with the U.S. Patent Office to show them and explain to them why your invention is novel, why it's not obvious, and help you achieve your ability to exclude others from practicing your invention. And I put this in bold, pay your fee, and it's not pay your fee to me, but pay your fee to the USPTO. Oftentimes, this is one of the bigger hurdles that folks run into, not because it's an extremely large amount of money, especially for small businesses as well as first-time patentees, but really because it is the surest way not to have your right to exclude others from the patent just because you forgot to pay your 7-year fee of $1,500 or whatever the case might be, depending on the size of your company. So I always highlight that. That's a low-hanging fruit that we always want to avoid. I've talked about the provisional application, and you'll all get a copy of this presentation, and I know it will be available as a recorded presentation after today. But the highlight of a provisional application is that it gives you a 12-month pendency period, allowing you to, as long as you disclose the full aspects of your invention, allowing you to take advantage of that earlier effective filing date to exclude anybody who comes up with something that would otherwise be considered as disqualifying prior art after that date. It allows you to have the earlier date to be able to still pursue your patent. Non-provisional application, as I mentioned, is the actual invention or the application to receive your patent on your invention. As a side note, there are many patent applications filed every year. Not listed on the slide is the overall duration of the patent process. It can last at times up to 3 years or longer, depending on the type of technology, the arguments, so to speak, that we get into with the USPTO for their attempts to try and invalidate your patent application. So that's something also to be aware of, the timing of a patent with respect to the ability to enforce trade secret rights, as Ziad was explaining earlier. There are tools for patents outside the United States under the Patent Cooperation Treaty, also known as the PCT. There's the World Intellectual Property Organization, which has its own set of intellectual property rules that patents sometimes are implicated in. And then also there's the European patent system, just as an example. There's also Asian patent systems and many others that have, for companies that are international, the right to expand the reach of a patent application that was otherwise generated first in the United States. And I list this as a patent case that you should know as remanufacturers. This 2017 decision in the Supreme Court is one that is of utmost importance for the remanufacturing industry. There's done many summaries on this and spoken many times about this case. I'm going to try and do it in 2 minutes using one slide with a screenshot from the beginning of the case. Ultimately, as it applies to us in this conversation in the remanufacturing industry, Lexmark, Impression Products v. Lexmark, was a case where Lexmark had a patent on injection printer cartridges, and Impression Products came up with a solution to effectively work around some software related to the refilling and then also came up with a sales strategy for selling the refilled printer cartridges in the United States and overseas. At the end of the day, there were several decisions made by the Supreme Court, but of utmost importance to us is the theory of patent exhaustion. It was best articulated in this case, and effectively what it stands for is once a patentee or the owner or assignee of a patent sends their product, an individual part, in this case, an individual ink cartridge, into commerce, they have lost their rights to enforce their patent as to that product. Not globally, so no one can come and create from scratch not on a wholesale approach where somebody can come from and build a printer cartridge, in this case, from scratch and be free from the remedies that would be otherwise available to Lexmark. But instead, in fact, the remanufacturing sense, having a product, putting that product through some sort of process to return it to like new or better, and then sell that exact product into commerce. This case stands for the notion that that is okay, and the owner of the original patent is exhausted and lost their rights to enforce that patent, again, as to that individual product. So brake elements or turbo elements or you name it, if it's something that has a patent, it's sent into commerce, and we legally, lawfully obtain ownership of it, put it through some sort of process such that it's not a new product, but it is simply a, lack of a better phrase, used product, even though it's like new or better. We are generally protected, and I say generally because there are certain factual scenarios that we would need to look at before we could certainly consider ourselves free and clear.
Thanks, Mitch. Now, if you don't have a patentable idea or you choose not to go the patent route, but you otherwise want to protect the secrecy of your information and you want to essentially maintain it as a trade secret, there are essentially two things you're going to have to do. First and foremost, you're going to want to identify your trade secrets, and then once you've identified what your trade secrets are, you're going to want to protect them. And we're going to talk about both of those items right now. One, identifying your trade secrets. Up here on the screen, you're going to see a list of categories of essentially types of information that can be a trade secret. Now, again, this is as long as these items are maintained as secret, that you take reasonable measures to keep them secret, and they derive independent economic value, as we talked about previously. And these items could be considered trade secret. So new technology, innovations, breakthroughs, customer lists, designs, processes, etc. You see here on the screen, price lists, marketing plans, strategic plans. These are just some examples, obviously, of categories of information that can be maintained as trade secret. And oftentimes, some of these categories aren't necessarily trade secrets, but as long as the companies take reasonable measures to maintain it as secret and it possibly derives independent economic value, as long as those things are in place, then you're certainly protected yourself to call it a trade secret. Now, whether or not it's actually a trade secret, I mean, sometimes that's up for challenge in courts. But as long as you've done those things, then it's more likely than not that a jury or a judge is going to rule your way in terms of what may constitute a trade secret. So we're going to talk about kind of taking reasonable steps under the circumstances to protect your trade secrets. We're going to kind of go through various examples. This is kind of the meat of this portion of the presentation in terms of what to do exactly in terms of how to maintain the secrecy of your trade secrets. First off, you're going to want to limit access of trade secrets to only those people who have a need to know. You might have heard this phrase because it's typically found in a lot of NDAs and things like that, where parties are obligated to only share information to those who have a need to know. So certain managers, engineers, for example, that absolutely need to know the trade secrets in order to conduct business or whatnot. You should limit it to those people. You want to implement and enforce effective internal policies and procedures and record-keeping practices that are aimed at safeguarding your trade secrets. You want to make sure that employees sign non-solicit confidentiality and non-disclosure agreements at the outset of their employment, and perhaps at reasonable regular intervals thereafter. You want to also properly mark confidential documents, and this also includes, native files and things like that. Oftentimes in trade secret cases, we have Excel files and other files that aren't images, like they're not PDFs that have a red confidential stamp on it. It might just be, for instance, a spreadsheet. I would highly encourage you all, to the extent that you consider information in those files to be confidential, that they should be marked as confidential, both on the document itself where possible, and also in the file name, for example, for native files and things like that. You're going to want to employ password protection and encryption to limit valuable information to those certain need-to-know employees. And you're also going to want to conduct exit interviews in which you identify the categories of sensitive materials in, for example, the exiting employee's possession, and require him or her to return the materials before departing. You're going to want to effectively manage your physical and electronic security. So if necessary, you'll limit access to rooms or areas where there is sensitive information, and screen visitors to your facilities and have them sign NDAs as appropriate. A lot of times you'll see, obviously, key card, badge access to sensitive areas of the workplace. And typically, if you're going to have sensitive information lying around, you're going to want to make sure that that you have effective security in place for those areas. You want to maintain IT firewalls, and you're going to also want to monitor employee use of the internet and block access to websites, the access of which could compromise your IT systems. So you want to make sure that, obviously, it's not easy for an employee to just essentially go out on the internet or allow themselves to be hacked, for that matter, and compromise your trade secrets. You're gonna want to make sure you don't leave obviously trade secret information just kind of laying around. Whether it's your visitors or a janitor or somebody else that can see it, and it may no longer be a trade secret. So these are a lot of the issues that come up, obviously, when we litigate these things, because the other side will often say you didn't maintain the secrecy of your trade secret because it was laying around, you don't have password protected computers, et cetera, et cetera. So you want to make sure all these things are put in place to maximize the chance that you've taken reasonable measures to keep it secret. You're also going to want to make trade secret protection a focus of your risk management, risk assessment regimen. And it's good practice to maintain a registry or something else that essentially enumerates all of your trade secrets. I think Kentucky Fried Chicken keeps a copy of their famous recipe in a safe somewhere that only few people have access to, but they have it essentially in writing. Not saying necessarily you have to put it on scratch paper and put it in a safe somewhere, but you should essentially have a list that is protected, obviously, that essentially enumerates your trade secrets. And it's good to know, obviously, which of your employees have access to which trade secrets, and make sure that those employees who do have access to the trade secrets know that the company considers such information to be trade secret. Oftentimes in litigation matters I'm involved in, a company representative will be deposed, or we'll depose a company representative, and they don't know what the company considers to be trade secret. And so oftentimes when they're deposed, they'll say, well, I don't know if that's a trade secret or not. And obviously, if you're on the side that's trying to make a case that it is trade secret, you're not going to want your managers and engineers and others who have access to this information say that they don't know whether it's a trade secret or not. You're definitely going to want them to be well trained to know what are the company's trade secrets, and to be able to essentially enumerate that if the time came to say, yes, absolutely, I have access to that, and that is a trade secret, and here are the measures that we take to protect it. You're going to want to develop a procedure for routinely reviewing potential cyber, physical, and other threats to your trade secrets, and implement effective measures to minimize the corresponding risk. Obviously, nowadays we certainly see and hear about a lot more breaches, security breaches, and viruses and things like that. So you're definitely going to want to make sure that you have all those things in place to be able to minimize any attacks that could compromise your trade secrets. And you're going to want to continually monitor your approach to trade secret protection, making necessary improvements along the way. I know it's also a good idea to put an executive or a qualified committee in charge of all of this stuff that we've discussed. You're also going to want to manage your suppliers, customers, other third parties who have access to your trade secrets. Certainly that could be through the use of NDAs with those customers and vendors, and making sure it's clear to them, obviously, which of the information that you consider to be a trade secret that you are sharing with them, and to mark it appropriately. Again, lots of times we see companies sharing documents with other parties, with outside parties, and even though there may be an NDA in place, if they don't mark it confidential, an argument could be had later on that says, well, you didn't specifically mark this document, so you must not treat that as confidential or as a trade secret. So you're going to want to make sure that you do mark all documents that you consider to be confidential, and including, like I said, a lot of times we do see natives that aren't marked, so those should be marked as well. And when I mean native files, like for instance, a non-PDF like the Excels and whatnot, that should be titled as confidential, particularly something that could be easily seen, maybe in bold or all caps, things like that. Just so, and you can also include other disclaimers. Obviously, you typically see those at the bottom of the documents that will say that the company considers to be proprietary and things like that. So it's always a good idea to have that in place. Again, so if it's not kept confidential, then it's not confidential. So you're going to want to make sure that your company brochures, your product guides, websites don't disclose trade secrets. You'd be surprised how many times a company actually lists something on their website, and then later they try to make a claim that that same information is a trade secret. And it doesn't take long for the other side to say, well, here's a screenshot of your website that lists the very information you're claiming to be a trade secret. So you're going to want to make sure that the stuff is not publicly disclosed. You also want to think about what information are you conveying to your customers. If it's covered under NDA and marked accordingly, you should be fine. But otherwise, lots of times companies are adamant that certain things are trade secrets, and then come to find out that they've been sharing it with other third parties that aren't subject to NDAs and things like that, which will obviously destroy the secrecy of the item and therefore lose its status as a trade secret. Severance agreements can sever restrictive covenants. So we talked about having employees sign certain restrictive covenants, non-solicit agreements, confidentiality agreements, also non-compete agreements, things like that. Kind of make sure that severance agreements don't essentially release them from certain obligations. You want to make sure that the enforcement is consistent and uniform. And I think we'll talk about this in another slide, but essentially, if you're going to enforce your trade secret protection, you're going to want to be consistent, because you don't want anyone to have an argument saying, well, this trade secret was also at issue in some other case, and you failed to protect it, so you shouldn't have trade secret status with it with respect to my case and things like that. So you're going to want to make sure you're consistent and uniform, and obviously take a look at the agreements that your employees signed to see kind of what protection you have there. The thumb drive. Today, this happens to be something that comes up in most trade secret litigation matters. Something as little as this device right here, obviously, that all of you are familiar with, and it's very cheap to obtain, but could hold a lot of data, a lot of documents. This seems to be kind of the reason why lots of things leave one place and go to a competitor. Employees are often fired or they leave. They'll typically stick this thing in a computer, download a bunch of information, and take it to a competitor. So you're going to want to put all those measures we talked about in place to kind of minimize the risk that does happen, including conducting exit interviews, things like that, where possible, to try to ascertain essentially what electronics the employee may have, and also maybe have your IT run assessments, things like that, as to what might have been downloaded, things like that. That's obviously saved companies before in terms of identifying the theft early on, being able to get into court and maybe get an injunction and stop them from essentially downloading it into a competitor's server, things like that. But but this is obviously just to illustrate how easy it is to essentially steal the information and take it on outside the company. Lots of times, with respect to trying to implement these measures, obviously lots of individuals and companies are cost conscious. If everything's going right at the moment, there seems to be no issues. There doesn't seem to be any kind of urgency, to spend money to protect anything or to do anything differently. But it's one of those things that just spending a little bit of money now to make sure that you put these measures in place, that you have the proper agreements, the proper security, things like that, really could prevent the loss of the entire business. I mean, we've seen it all too many times where companies essentially fail to do that up front, and they pay essentially moving forward in terms of trying to enforce trade secrets that they didn't take reasonable measures to protect. And it's going to end up costing them not only hundreds of thousands of dollars potentially in protracted litigation, but also the risk that there's a determination that their item is not a trade secret, and therefore essentially the value of their business could substantially suffer as a result of that. So you're going to want to spend that money to make sure, obviously, you've protected your trade secrets, and also as a deterrent effect. So obviously enforcement. So to the extent you feel that your trade secrets might have been compromised, if you sit on your hands and don't do anything about it, there is a chance that obviously you might lose its status. It might lose its status as a trade secret, and also you're going to want to deter others from doing the same. So companies who go out there and aggressively enforce trade secret misappropriation, things like that, certainly can deter others that are either still currently in your organization or might have also left from doing the same if they see that obviously you're not going to hesitate to essentially go into court, seek an injunction, and shut them down, or otherwise go after them for the damages that they might have caused from taking your trade secrets. So again, just kind of circle back. You're going to want to act before it's too late. Be proactive. You're going to want to obviously defend your rights. Send cease and desist letters to the extent you obviously think there's a risk of misappropriation of your trade secrets or patent infringement. And in the event of perceived or actual misappropriation, seek injunctive relief. Again, you don't want to sit on your hands. You might just lose those rights. Oftentimes, judges, one of the main reasons they deny injunctive relief is because the company waited too long. Otherwise, maybe all the other factors are there, and they would have a substantial likelihood of success on the merits and whatnot. But judge might say, hey, listen, this all sounds great, but why did you wait 10 months? Why did you wait 6 months? Things like that. So you're going to want to act fast, obviously, to the extent you feel that there's perceived or actual misappropriation.
All right, thanks, Ziad. So I'll just bring us back to where we started this decision-making process. Again, looking at the decisions that need to be made once we have an innovative idea, the process that should always be followed is that information is kept secret. The information is subjected to NDAs. You don't bring competitors or customers or anyone into your plant without signing in, without agreeing to confidentiality obligations. You don't send out information without some sort of terms and conditions, keeping that information confidential. And then from there, it allows your business to make a decision on how to protect that IP on a going forward basis, whether it's patented or not patented. If it's something that can be patented because it's new, novel, and not obvious, and it otherwise satisfies all the criteria necessary to be able to achieve patentability, or if it's something that derives its value from being secret, like the Coke recipe or the KFC recipe. We don't, if I'm KFC or I'm Coke, I don't want people to know that information because I can protect this indefinitely as a secret. As long as I can protect it indefinitely as a secret, I can continue to get value from the fact that it is a secret. So to recap, it's important to understand what your company's IP is and to be able to identify what the secrets are and what is worth pursuing a patent over. Know, first of all, and really foremost, who owns the data, whether it's the company or if it's an employee, or if it's joint ownership. Protect your information, whether it be through a non-disclosure agreement, through separate agreements. The next bullet point says, hire and fire wisely. That goes back to not only determining who the right employees are for your company, which we practice that every day with trustworthiness and so on, but also having the right processes and procedures in place, securing information, running the appropriate exit interviews when necessary, when an employee leaves the company, and continuing to inform your employees of what is confidential, what's not confidential, what processes they should follow when dealing with customers, as well as suppliers, is an important part of maintaining your company's intellectual property. And then, as Ziad was just explaining, move quickly if anything has been compromised. Just a simple demand letter can be enough to show that the company was moving to protect its intellectual property sufficiently in order to prevent an adverse decision when an otherwise positive decision could have been had in your favor. When as we wrap up this presentation, making the decision between trade secret and patent is really not a one-size-fits-all approach. It needs to be company specific, and it oftentimes needs to be product specific. It needs to be intellectual property specific. There are situations where your company might decide to protect a trade secret in one situation, and then in a similar product, when a trade secret could have been a viable opportunity, a patent approach could have been pursued. If you're interested in talking more about what the right approach is for your innovations, you should talk to a trade secret attorney or a patent attorney and explore those options. And if anyone tells you there's not a balancing act to be made, they're not the right person to talk to. And finally, rest assured that there's not really a way to go wrong in this, other than basically the decision that you make will impact the ability that you have as a company to based on how long you'll be able to protect that intellectual property. Whichever you choose, whether it's patents or trade secrets, both are very valid and valuable options. Not a lot of information is often discussed about trade secrets. Patents are certainly more well known, but trade secrets are viable, they are valid, and they are equally enforceable with respect to your company's intellectual property. And with that, we have concluded our presentation, and we're open to questions and hopefully to be able to provide some answers.
Well, thanks, Mitch and Ziad. Really a great job going through the two definitions, and it was really neat how you noted how in many ways they are opposite one another. Thanks for taking us through the decision-making process and showing how one can actually combine a patent and a trade secret, whether it's one being product and process, and even taking us through real-world examples, patent exhaustion, and Mitch, as you noted, a case that we as remanufacturers should all know, and Ziad, just really interesting on the inexpensive thumb drive. And before we get to the questions, I'll just note too, what trade secret presentation will be complete without Coca-Cola and Kentucky Fried Chicken. So really good stuff. And we've got some really good questions too. So let me start with the first one. What protections are on drawings or prints? It's not a lot of expression, could be a thin copyright, but prints inherently need to be shared with suppliers and customers.
Yeah, so really just obviously with respect to things that are on print, so you're talking about, like, if you're talking about drawings and whatnot, certainly, I know in the automotive world particularly, there's certain CAD drawings and other type of 2D type drawings that are very, companies will consider proprietary. So, oftentimes the design and other processes or procedures that might be ascertained from those prints are considered to be trade secrets. Sometimes not necessarily the ink, essentially on the paper. It's the processes and procedures that are laid out in those drawings, things like that, that might be considered a trade secret. Obviously, as long as it's you've taken reasonable measures to keep it secret and it derives independent economic value, then it can be a trade secret. And that includes pretty much all forms and types of financial, business, technical, scientific, economic, or engineering information. So there is no limit essentially as to essentially what could be a trade secret. Obviously, there's lots of case law out there that interprets whether or not certain things can be a trade secret, like customer lists. I mean, there's cases that go either way as to whether a customer list can be trade secret, certain drawings, things like that. So it's probably going to be a case-by-case basis depending on the content of the drawing or the information and whether or not those other factors are in place, the reasonable measures, and it derives independent economic value.
And I'll just double down on that. There's other bodies of law that come into play as well. In the case of a 2D drawing, let's say that we've marked it confidential, we provided it to our customer under a non-disclosure agreement, while we perhaps there's implications of whether or not that information is readily ascertainable from some other place. We certainly also have the contractual obligations that go along with the non-disclosure agreement. To the extent that we've patented certain features of that product, we may have patent protection. And then again, if the only information that's been shared is between us and that customer, in the case example of the 2D drawing, it's still considered secret if it's shared underneath a non-disclosure agreement. It's not something that's been disclosed to the world. So you are able to, in a general sense, as long as you act diligently in your protection strategies, you're able to continue to protect that as a trade secret, all things considered.
Mm-hmm.
So Mitch and Z, maybe you've answered this next question because it goes right into the same topic. But let me just read it and see if you have anything else to add. It says, we have mutual NDAs with our customers. These customers routinely conduct audits at our site. Besides reminding them of the NDA or the NDAs, is there something else we should do?
Well, if you're talking about like on-site visits where there might have access to additional information, or sometimes plant tours, things like that. I mean, typically sign-in, you want to have sign-in sheets and maybe like acknowledgments that they might have access to or might see essentially some proprietary information while they're there, or that things might be shared with them. So obviously an acknowledgement, and obviously depending on what they have access to when they're there, to make sure other security measures might be in place, obviously key cards, things like that. You're not going to obviously want someone to just be able to walk in and have immediate access to the confidential information. So other than, like I said, other than reminding them, obviously the NDA obligations, you can go a step forward and have them sign something while they're there acknowledging that they're going to have access to some proprietary information, that they have to keep it confidential.
Okay, thanks. I think we have time for one more question. And let me present it this way. There are two companies, both of them manufacturing companies. One chooses to maintain an idea as a trade secret. Are they restricted in business in any way if another manufacturing company comes along with the same idea and secures a patent on that idea?
So all things considered, the short answer is yes. The trade secret value and the intellectual property rights are derived from the fact that the trade secret is in fact secret. It is enforceable to the extent that someone has taken it wrongfully and used it for their own gain. Ziad mentioned the phrase reverse engineering earlier. That is something that if all the boxes are checked on what is reverse engineering and what is not reverse engineering, if those are all checked, that is what the law considers to be a proper means. So it's not as though the competitive company was able to come up with this patent that has some sort of novel characteristics with respect to what was previously held as trade secret. If it certainly, in order for them to receive their patent, they would have to check all the boxes of patentability, novelty, non-obviousness, those kinds of things. But assuming the answer is yes, they're able to do all of those things, and it's somehow slightly different than what was trade secret. If that trade secreted product or trade secret protected product or process infringes on each and every claim or element of a claim of that then issued patent, there's no more opportunity to exercise that trade secret because of the existence of the patent. It's a very complicated question because then the question becomes, well, it's a trade secret, so therefore I've protected it, kept it secret, nobody else knows about this. If the patent is exactly the same as what my trade secret is, now there's issues actually with the patent. And there's certain processes, inter partes review, post-grant proceedings that can take place in the patent office for that trade secret owner to challenge the validity of the patent itself. So it just got very complicated with what seemed to be a straightforward question. But if the patent exists separate, with something separate, new and novel and not obvious from what was previously trade secret protected, the trade secret person loses. However, if it's exactly the same, the patented product, and exactly the same as the trade secret protected product, perhaps the trade secret owner has an ability to challenge the patent, and maybe they could win.
And I'll just quickly add that, if two companies are independently developing something and one patents it and the other doesn't, I mean, the other company probably has to think about, well, was it even a trade secret to begin with? I mean, if somebody was able to develop the same exact thing separately, or if an item can easily reverse engineered, then if a company choosing to maintain it as a trade secret doesn't necessarily mean it is automatically going to be a trade secret. So you should also think about that as well.
Well, Mitch Zajac, Ziad Hermes, thank you very much. We really appreciate you guys coming together and doing this. And we're going to make the presentation and the recording available to those on the call. Again, Mitch is the patent attorney. Ziad is the trade secret expert. And again, thanks for taking us through these two topics together. And with that, I'm going to after the thank yous there, just want a couple of really quick notes. Anybody participating on today's call that may not be a member of MIRA, Cheryl and I would love to speak with you about the value proposition. And many of you will be at Apex. We'll see you next week. And we just wanted to just say again that Wednesday is our big day for the remanufacturing experience. In addition to the section, we have our executive council meeting and our reception. If anyone is interested in attending those, please contact us. And lastly, we have another webinar that's coming up soon. We will release a date, but for those of you that are in our certification program, Manufactured Again, or are interested, please let us know and we'll be communicating a date. With that, again, Mitch, Z, thank you very much. Really appreciate your time today, your expertise. And again, for those on the call, we will make this presentation available. Thanks for your time. Have a great day.
Thanks,
Thank
everyone.
you.